In the last video, I have discussed about the all contracts are agreement, but all agreements are not contract. But today's discussion of my topic will be the later part of that statement, that is what to be included along with the justification which you made in the previous lectures. So today we are going to see the essential elements of a valid contract, which has been laid down under section 10 of the Indian Contract Act. And I'm going to discuss this one by one, the essential. There are 10 elements are there. The first essential element is the offer and acceptance. So there must be an lawful offer, and acceptance to the offer must be absolute, unqualified, and it should not have any condition on it. Because when you are accepting it, there must not have any condition or any counter offer to it. Then there will not be result in the valid contract. But if there is a lawful offer and acceptance to an offer, absolutely, and that is resulting to a valid and binding contract. Now, second essential element is the parties must have intention to create legal relations. So there must be an intention to create among the parties, and it should have the agreement which should be attached by legal consequences and create legal obligations. So very important point to be discussed under this heading is there must be the intention among the parties to the agreement to create a legal relations and create a legal obligations. So agreement which is of a social or domestic nature do not contemplate legal obligation, and as such they do not give rise to a contract. So it is very clear that if the agreement are of social or domestic nature, they will not have any intention to create legal relations, and therefore they do not constitute a valid contract. And this is very, very important elements to be present to have a valid contract. Now here we can have one illustration, that is A who promises his wife to give a sari if she will sing a song. Now B is the wife who sang a song for his husband, but A did not brought a sari for her. So therefore she brought an action on the point that she couldn't get her promised things. But B could not bring an action in a court of law to enforce the agreement, as it lacked the intention to create legal relations. So intention to create legal relation must be there, and then you can succeed in a court of law. So here in this point we can discuss one very important and very famous cases, that is Balfour versus Balfour. So it's a very lengthy the facts are, but I am giving it a brief and short. That is both husband and wife who went to Ceylon for holidaying, but in fact the husband having a job in England. So while they are enjoying their holidays, so wife got and she suffered sickness or illness, and due to this she could not come back to England, and which there was a due from her husband to come back to join his job in England. Then she stayed over in Ceylon, and husband said, I will give you the maintenance, so you stay over in Ceylon and I will join the job. So immediately he rushed to the England for his job, and she stayed over there, and he was paying maintenance to her. But in fact, after giving for few months, he has refused to send expenses maintenance to her, to his wife. So what wife she did here in this case, she sued for breach of a contract. Yeah, definitely she will bring his case because there is a breach of the agreement. That means there is a breaking of the agreement. So her action was dismissed on the ground that no legal relations had been contemplated, and therefore there was no contract. So she said that there was no maintenance, so that is why I should not bring an action, because this agreement has been broken down. So but court has dismissed on the ground that their parties among them They were not having any intention to create relationship, and therefore on this point the court has dismissed the petition, and therefore there was no contract. That's the point raised, that no contract, no legal relations, no contract. Therefore, the petition was failed in the court of law. The next important element is the lawful consideration. Consideration, all you aware that is something in return. The something in return must be given. One party has to get something and other party has to give something and get something. So something in return must be there. So lawful consideration, that is a consideration must be lawful. Consideration as the price paid by one party for the promise of the other. Because one party has to pay, and because that is promise made by the other parties, that is why they has to pay. So this lawful consideration must be there. If the consideration is not lawful, then definitely there cannot have a valid contract and concluded contract. The next important element is that is capacity of parties. Now you suppose if parties are not capable and they are not having a capacity, how you can enter into a contract? So capacity of the parties, how to explain this point we will see. The parties to an agreement must be competent to contract, otherwise it cannot be enforced by a court of law. So in order to be competent to contract, the parties must be of the age of majority. Now what is the age of majority? Age of majority generally it is 18 years. If the person is appointed under the Guardians and Wards Act, his age of majority will be count at the age of 21 years. So generally it is 18 years. And the party should be of sound mind. So that means he must have a sense to understand the terms and conditions and consequences of the contract or the agreement. If it is not there, then how can he enter into an agreement or enter into a valid contract? It is very important to be present. And third important point, on the point of capacity of parties, he must not be disqualified from contracting by any law to which he is subject. So he should not be disqualified by law. The parties must be he must be qualified, should not disqualify by the law. So this is the essential elements is very important to have a valid contract or a binding contract. Now next elements is the fifth point of elements is pre-consent. Now before that we have to see what is consent. Consent is what? The meeting of both the parties must be in the same thing, in the same time, in the same sense and at the same place. That should be very clear. So that is a meeting of the mind of the person. When they are giving their consent, the consent must be of free. It should not be given out of any fear or force or any other things. So it should be given freely. So how to write on this point now? The consent means the parties must have agreed upon the same thing in the same sense and at the same time. Therefore, the consent of all the parties to an agreement must be free to constitute a valid contract. So they must be given their consent freely. And the next element, sixth element is the lawful object. If object itself is not lawful and if it is prohibitory or illegal, opposed to public policy, immoral, then how can you conclude a valid contract? It's a very, very important point. An object to be there for a contract. So to constitute a valid contract, the parties to an agreement must agree for a lawful object. So their object must be lawful. If it is lawful, if it is not there, then how can you conclude a valid contract? The seventh point of essential elements is the writing and registrations. So as you all know about the agreement, you can make orally or written. So two ways we can make our agreement. But here is a question arises. Nowadays the written form and various ways out is there. It's a more advanced technologies we are using it. But still, it is always advisable to be writing, and registration is very important. If suppose there is one exceptions to the consideration, that is, as we know, no consideration, no contract. If there is no consideration, there cannot have a binding and concluded contract. Therefore, it required that exceptions. So when there is a law, there is an exception. So in that exception, it is says, even if it is no consideration is there, then the contract will be amount as a valid contract. Why? Because it is given out of love and affection. When it is given out of love and affection, then that contract will concluded into a valid contract. Then in that case, suppose you are saying out of love and affection and you are getting your promised things, but you forgot to register your agreement paper, then even in later case, in future, if any dispute arises, you might be thinking that your agreement is very ready and I will win the case if dispute arises also, but it is not like that. So it has to be registered. If there is no registration is made on your particular agreement, then in future case, and if any dispute comes before the court will say, where is your registration? How can you say this is genuine documents? So this may not be the genuine one, because it's not having a value, and evidentiary value is not there. Then how the court will entertain or admit your petition? So it will be rejected on the point of rejections, on the point of registrations. Now we will explain on this point that agreement to be valid must be in writing and registered. So why we require? So there is an example we can take here. So that agreement to pay a time barred debt must be in writing and registered. So time barred debt. When your debt you have taken, your liability is there, you have to pay back, repay it, but your debt is already been expired to make your payment or repayment, then how to recover by the party who has given it? So in that case, you have to make an assurance, giving an undertaking by writing and making a registration that you are going to pay your repayment of your loan amount in the later date. So this is a time barred debt. How you can make it clear by making it in writing, and registration is very compulsory. The next point of elements, that is of 8 point, that is of certainty. Certainty is also very important. If your contract itself, the meeting of a mind of the person is not on the certain things, then how can the agreement will be entered into a contract? So therefore, in order to give rise to a valid contract, the terms of the agreement must not be vague or uncertain. So you have to say that it should not make any vague things. It should be very clarified, specified, definite things. It's very certainly you have to make your objectivity and your terms and conditions of the contract. Otherwise, it will not have a valid contract, because it may cause confusions in the mind of the parties. So that should be very clear before you are making or before you are entering into an agreement, which will amount as a valid contract and the binding contract. And the 9 point of essential elements is the possibility of performance. So before going to enter into an agreement, you must also look into the terms and conditions, whether the point things you are agreed upon, whether there is a possibility are there or not to perform. If it is not possible to perform, then how can you enter into a contract? So in that case, what you have to do? So you have to see the possibility is there or not. So the essentials to a valid contract, that it must be capable of performance. So if the act is impossible to perform physically or legally, the agreement cannot be enforced at law. So if you could not physically or legally perform the part of the contract, then how you can enforce that contract at law? So law will straightforward will dismiss your petition on the point of it's physically or legally impossible to perform. So here you can give example that A agrees with B to discover treasure by magic. So agreement is not enforceable. So could you think that anybody could bring a treasure by magic is possible? So that kind of an agreement cannot be enforced in a court of law. Similarly, if A agrees with B to bring a life into a dead body, is it possible? So that agreement will also will not be enforceable at law. And the lastly, that the 10 points of essential elements that has to be discussed is the not expressly declared void. So the agreement must not have been expressly declared to be void under the Act. So the agreement which you feel that it is not valid by law, or it is made by the Act itself, which is void. Void means void from the very beginning. There is no contract at all. Then how can you enter into such kind of an agreement? So before signing your agreement paper, you must see whether that agreement is possible, or Act has given a validity or not. We have to see it. So for example, certain kinds of agreements are there which are made void by the Act, that is agreement in restraint of trade, agreement in restraint of marriage, agreement in restraint of legal proceeding. These are the certain agreement which has already been made void by the Act, that we will discuss in the later part. So that's, if it is there, so that kind of agreement should not you enter into. Otherwise, that agreement will not be concluded into a valid contract. Now, to justify your statement, you have to include these essential elements also in your answer. Otherwise, your answer will be half-hearted without writing these essential elements to the point. So here you can very well write two questions. One may be all contracts are agreement, but all agreements are not contract. Similarly, if they may ask you definition of a contract, as well as what are the essential elements of a valid contract as per section 10 of the Indian Contract Act, that will, the two purpose will fulfill by this to complete discussion on these two videos. So this is the suggestions I have given it. You prepare it and you will solve your two purposes with this question. You can write it. And in my next video, if you want notes on it, I can also provide you in my next videos.